This is part 2 of my interview with Alan Gongora with the Langone Law Firm in Medellin, Colombia. Follow along.
You're watching dcbornrob, Erasing Borders. Traveling to Colombia? You come to the right channel.
Okay, good morning, good evening, good afternoon, wherever it is you're located. My name is Rob Christian, also known as DC Born Rob or DC Rob or Rob. I answer to them all. Thank you guys for watching. This is part 2 of my interview with Alan Gongora with the Langone Law Firm in Medellin, Colombia. Again, we're talking about marriage, divorce, kids, alimony, child support. Hopefully we can get through as many questions as we can, but be aware that I did have a couple of glitches in our conversation, so I did not get the very end, but I have enough to share, and I hope this is beneficial for some of you guys. Thanks for watching.
Well, here's a question. If a foreigner wants a divorce, what happens to any property acquired after a couple is married?
Okay, so divorce is interesting. Okay, so and a lot of this, I assume your audience, I assume it's mostly American, will probably be, some of this will be familiar, right? So if you get married through, again, the church, and I keep on doing this, I apologize, but it's sort of the best way to explain it. So ceremony, church, ceremony, normal, civil marriage. So this is marriage, right? And to end this relationship, you have to get divorced, right? So when someone is getting divorced, the most important question is, did you sign a prenuptial agreement? Did you sign a document that explains what happens to all your property and other things in case this relationship ends, in case the marital relationship ends or is terminated? And if you have signed a prenuptial agreement, then that will clarify a lot of the lack of clarity, I think, for what could potentially happen, because it will depend on what the document says. There are two flavors of prenuptial agreements. So there's one that's a complete prenuptial agreement. It's the one we love to organize. It's the one we recommend. It's the one that everyone listening and hearing this should absolutely get. And that's the complete prenuptial agreement. It is a simple, it usually could just be 2 pages. It's super simple document. It's inexpensive. It's basically what you want. And all it says is the following. If we enter into this relationship, no property will become marital property. Done. That's it. That means that whatever is yours remains yours. Whatever is theirs remains theirs. Whatever you buy during the relationship is yours, and vice versa. And that's it. And it's ironclad. Colombian law accepts it. It's abided by it for many, many years. It's a very solid strategy to minimize risk when you enter into a marital relationship. The same thing is true for the common law marriage situation. So if I think I want to live with someone, I want to sign that document before I even start. Okay, you can sign it afterwards, before that 2-year mark. Courts still allow that. That's okay, but it clarifies the legal risk if you do it earlier. The earlier you can do it, the better. But I'm comfortable having a client sign a document like that before the 2-year mark. Okay. Now, the second flavor of prenuptial agreement is what I think a lot of your audience will likely have heard about. This is where, you clearly state, okay, if we get divorced, you get the house, I get the car. This account, everything in it is yours, et cetera, et cetera, et cetera. That's an incomplete prenuptial agreement, right? It creates marital property, right? And what tends to happen is if there's an actual divorce, guess what? Your spouse is going to start fighting about what should be in the marital property kitty, basically, right? We know the document said X, but you know what? You actually told me something different afterwards. Or are you sure this says what it says? Is this property correctly included into this document? So suddenly there's a fight, and that could take years to resolve. So once again, I love the first flavor because it is straight down the middle. It's clear. It's black and white. That's what everyone needs. And by the way, this is a lawyer telling you to do something that's way cheaper than the other option, right? How often does that happen? Don't go for the more expensive option. Go for the cleaner, cheaper, simpler option, okay? So again, to answer your question, if there is a prenuptial agreement, we have to figure out if it's the first flavor. If it's the first flavor, whatever is mine, whatever is theirs. That's it. If it's the second flavor, it depends what the document says. So the document is going to say something like, if I get divorced, you get the house, I get the car, etc. So that will depend on the document. And whatever has been obtained and acquired during the marriage will likely fall into the marital property category. And that's what will need to be determined during the divorce process. Because suddenly I got married, I have two houses, but suddenly I got married, a year later, I buy two more houses. Those two houses were not in that prenuptial agreement. So now we got to figure out what to do with those two houses. Does that make sense?
Mm-hmm, sure. I would think the problem with the first flavor is
right. Now, one last point.
I was going to say, I would
Go ahead.
The problem with the first flavor is getting the young lady to sign and agree to this.
That is true. But that is now a more of a personal issue as opposed to a legal issue.
Yeah.
And believe you me, I have been in those conversations with clients because for some reason, clients think that if we explain it to them, it makes things easier. It does not make things easier. But bottom line, it is in your best financial and legal interest to go for the first flavor. One last point here, or at least two additional points. You want to ensure that the other side has a chance to have their own attorney. You want their attorney to review the document, edit it, provide comments, etc. You want to make sure that the other side has representation. You don't want to have a fight down the line because you never had that, they never had that opportunity to talk to a lawyer about what they're signing, right? And then the second thing I think I mentioned, again, I just want to complete the answer to your last question, and that is, if you're getting divorced and you're trying to figure out what to do with property and you don't have a prenuptial agreement, then suddenly everything's on the table. It's just like a regular divorce, right? You're going to have to figure out, what to do with these properties, right? What will a court determine? And in general, anything that came in during the marriage, both spouses have an economic financial interest in, right? And that then you're getting into the normal divorce proceedings where you got to figure out if there's anyone at fault with the divorce. You got to figure out if anyone needs to get, added alimony. You got to figure out if, these properties that you purchased, can they be just cut down the middle? Is there a reason why they should be more yours than theirs? All that stuff is, quite frankly, it's just part of the normal divorce process in Colombia.
Okay. I thought I was going to add a question, but I think I have it here. And that is, what if the foreigner from another country who comes there and he passes away? Does it matter how he passes away? Does it matter if he was killed? Does it matter if he just died of a heart attack? Then what happens to the property then, even with a prenup?
Okay, so if the party passes, then various things come up, to kind of review or to be discussed, right? So the first is there a prenuptial agreement, right? So if there's a prenuptial agreement, that holds. Basically, his stuff or their stuff goes into his estate, right? And the normal laws of estate law come into play, so he's going to have heirs, right? He is going to potentially have a spouse as well. So basically, it's just a good amount, a portion of his estate will be divided between his heirs depending on estate laws. The second question is, or the second issue is, the person have a will, right? So if the person had a will, the will likely determine the disposition of those assets with one huge caveat. Colombia is one of these places where you have very huge limitations in terms of what type of dispositions you can make in your will, because automatically your spouse will likely get 50% of the marital property. You can't disinherit your spouse under Colombian law, right? You also can't, for example, disinherit, that third child that you've had some issues with that you don't want to give anything to. Under Colombian law, the people who are heirs will automatically receive a portion of the estate by law. Now, there's a portion of your estate that you can play around with, for sure. But that portion will depend on the circumstances, but it's way smaller than what I think a lot of your viewers might have assumed before this conversation started.
Okay, what if your will is a U.S. will? Does it supersede the Colombian authorities?
So once again, think about this in sort of a very practical way, right? So in the practical sense, your will in the US is under Colorado law. It's under Wyoming law. It's under New York law. Mm-hmm. And it's going to say what it says. I leave this stuff to these people. But it's under US law. It's not under Colombian law. So unless there's a will under Colombian law that says what happens to your assets, then it gets tricky. Technically speaking, your will is still valid in Colombia. But for that will to be valid, to be executed, to be useful, you need to have a local court certify, literally decree, say that this document is valid under Colombian law. And that process takes years. Literally, it could take 3 or 4 years. And it's very expensive, right? So the much less complicated option, and this is what we recommend to our clients, is pretty simple. Have a US will for your US stuff, even your international stuff, and have a Colombian will for your Colombian stuff. That's it. Your Colombian will determine your Colombian stuff. Your US will determine everything else. And that will save you a bunch of money and 3 or 4 years trying to get that will to be recognized under Colombian law. Simple as that. Does that make sense?
Okay, but either way, your heirs still are eligible for 50%, correct?
So your heir, that's right. So let's talk about, and I don't want to get too much into detail here because it gets very complicated, and we would actually need one of our family law specialists to actually be involved beyond a certain level. But in general, if I am an American, I'm in Colombia, I die intestate. In other words, I don't have a will. I don't have a prenuptial agreement, and I have a wife in Colombia. My wife in Colombia, technically speaking, will likely inherit 50% of my marital assets. Now, marital assets is a very specific type of set of assets. It's not necessarily the money I got 10 years ago when my mom died, right? Through inheritance. It's not exactly my property in Boca, in Florida, right? Because I bought it 20 years ago, right? Marital assets could be things like I bought in Colombia. It could be stock that I bought after I got married. It could be the appreciation, in other words, the valuation increase in my property in Boca from the date that I got married to the date that there's a disposition on, or at least there's a decision on what happens with my estate, right? All those things could be marital property, right? So my spouse will get 50% of that. Well, correct, we'll get that. And then my estate could get a piece of my marital property as well as everything else that's still mine, right? And then my heirs, my children likely will get my estate, right? Less estate taxes and some other taxes as part of the process.
Okay. And you just answered my next question with that one.
Good.
Okay. Actually, a couple ahead. Well, here's a good one. How does custody work if the couple gets divorced? Who gets primary custody, in other words?
So this is a pretty short answer. And the answer is that under the law prefers joint custody because the law prefers a child to have contact and custody between the two parents. In practice, though, and again, I am a corporate attorney. I do mostly business law, but I've had to see in a lot of very, very harsh, very aggressive divorces, particularly in Colombia. Again, it's not something I ever thought we would do as a law firm in New York, but we do it because it's part of our service in Colombia. And in practice, here's what we see. We see a spouse, just like in the States, pushing for as much leverage as possible. So you have a lot of people being accused of using drugs, a lot of people being accused of abuse, a lot of people accused of just things that would make them unfit parents, right? And this unfortunately happens way more on the side of the women in Colombia because it's still a very patriarchal sort of structure. It's still very pro mother, right? I think in the eyes of a judge, not necessarily the law, because the law says, let's make sure the child has, two parents and they're actively engaged in their life and they have joint custody. But in practice, when a nasty divorce happens and the divorce isn't amicable, things go haywire. And the strategy is always, let's fake the other person as an unfit parent. So because I want sole custody. So unfortunately, what happens is women usually, not always, but usually get sole custody in a situation where there's a very acrimonious divorce. That's the way it works. And unless there are very clear impediments for that person to be their primary custodian, in general, if it's very acrimonious and these types of allegations are made, in general, usually the woman will get custody. But again, the idea hopefully is that there is joint custody and that this process is amicable so you can avoid a lot of this unpleasantness.
Okay, so if there is a divorce and the mother gets primary custody, does the father have visitation rights or do they have to work this out?
Yes. No. Again, in practice, let's back up. If someone is going to have a divorce or they're thinking of ending their common law relationship, what they really should do is they should sit down and have a very serious, very open, very empathetic discussion. They should figure out exactly how to divide up their assets, what to do with custody, which is your main question right now. Is there alimony involved, et cetera? And they should do it sooner rather than later, before you talk to a lawyer, before you get one of these guys who are irresponsible, who might just focus on making as much money as possible, but making things really complicated, feeding on the fears of their clients, feeding on their anger and hurt. And they should really sit down and have a very reasonable conversation as to how to go from there. Because again, these are parents, these are human beings. They definitely want to do certain things for themselves and for their child, but they have to realize that they have a responsibility for life, right? They have a child between them, right? They have to make decisions that is in the best interest of that child. So ideally, all of the stuff is sort of nailed down beforehand. And once everything is organized and finalized, that's when the lawyers can come in and they can hopefully do a good job putting that idea into a workable document that's approved by a notary / administrative law judge, right? That's the ideal scenario. If that's not possible, then we're now, unfortunately, in probably in an adversarial situation where, your lawyer needs to be, careful. They need to be very aggressive, and they need to represent you just like in the movies. You don't want to be in a situation where you're at a disadvantage because of your lack of knowledge of Spanish, for example, in Colombia, or your lack of understanding of the process in Colombia. You need a lawyer that get all that stuff, and that you feel comfortable that will be very, will represent you correctly. Now, one last thing here before I'm done with this question, and that is, let me step back a little bit, and that is, first came to Colombia, I had that New York lawyer mentality. So a lot of these litigation / certain family law situations, my perspective was very, okay, let's go nuts. Let's go aggressive. Let's represent our clients to the max. And one last thing you should note is that it doesn't always work that way in Colombia. A lot of the times, even if you're being aggressive, there's an element of being congenial between the lawyers, and there's an expectation of that in the court that is absolutely absent in a place like New York courts, okay? So even though you're coming in with a very aggressive posture, that's your culture, that's what that's what you want to do, you should absolutely know that, you can't always do that, nor will that attitude, that way of doing things will get you what you think you'll get like back home, because back home, that type of aggressiveness is expected, and in some ways will get you certain things, whereas in Colombia, it could be counterproductive. So talk to your lawyer about this, because we always have this conversation with our clients, trying to tamp down their expectations as to how aggressive we could or should be locally.
Okay. So if let's say the mom gets primary custody, of course, the father will have visitation rights, I'm sure, which can be worked out, but how does child support factor into that? I mean, who creates the
Right. Once again, I go back to the.
No, I'm sorry.
Yeah, I go back to the conversation on trying to make things amicable. Ideally, child support is something that has been agreed between the parties, right? That's the idea. That will save you money. It will save you the annoyance factor, the heartache of having to go through a formal divorce proceeding. Try to do that. Now, if you can't do that and you leave this up to a court, it's very similar to what happens. The idea is, what's in the best interest of the child? How has the child lived up until this point? And remember, that child has a certain lifestyle because you, I assume, have helped develop that lifestyle. That child has, they live in a certain part of town. They go to a specific type of school, right? They're used to a certain type of diet. So what the court usually does is that they look at that lifestyle and they go, okay, well, the mother has no income. You have some income. Now it's on you to make sure your child continues to have the lifestyle that they used to have, because that's in the best interest of the child. Now, again, there's some variations here. Facts will change depending on the situation, but in general, that's where they're going.
Okay. So let's, on the same divorce channel, if let's say this couple gets divorced, but the foreigner wants to move back to the United States, can he take the child with him?
I go back to the same thing. Hopefully this is something that has been negotiated and finalized between the parties. Don't deal with lawyers. If you can avoid the lawyers, way better, way cheaper. It's for your own peace of mind. Again, that's the fifth time I'm saying it. But if that's not viable, a court will likely determine this, right? So if there's joint custody, right, if that's what the court determines, and you're living in the States, it could be a situation where there's joint custody. Maybe the child lives part-time in the States. The issue there is always the same. You don't want to disrupt the child's life too much. They have to go to school. Can they really go to two schools in a calendar year? Probably not. Which mean that, they might have joint custody, but the child lives mostly with their U.S. parent because that's in the best interest of the child. I don't know. The court will have to determine that. But unless it's decided between the two parties, and unless it's somehow negotiated through the divorce process, the decision will be absolutely made for you.
Okay. So my next question, I think, is going to follow along that same line. But if the couple is divorced, does either parent have to pay spousal support?
And the answer is likely to maybe to who knows. It just depends on the situation. So I go back to the argument, or at least the example earlier, and that is, your spouse has a certain lifestyle. She lives in a certain part of town. She's used to whatever. So when you divorce, the court will take that into consideration, but they'll also take into consideration someone being abusive, someone being, unfaithful. All the normal things that a lot of these family law courts throughout the United States normally take into account will fall into this determination.
We have a YouTube channel, like it. Please comment and share if you like the video. Please subscribe and kick the bell.